Funding for this program is provided by the National Institute of Justice.
Hello, I'm James Wilson. The Fourth Amendment to the United States Constitution states that, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, unquote. If the police collect evidence in a way the courts consider unreasonable, that evidence will ordinarily be excluded from the trial of the persons whose rights were violated. It is no easy matter, however, to decide what kind of police search is reasonable and what is unreasonable. When can they stop you? When can they frisk you? When can they search you, your car, or your home without a warrant? When do they have to get a warrant? From watching police shows on television, you may think you know what the police can and cannot do. If so, you especially should take this test. Watch the following dramatizations carried out by experienced police officers of typical encounters with citizens and decide whether the police action under current law and court decisions is proper or improper. And then listen to our three experts: Michael Farrell, Assistant United States Attorney; James McComas of the District of Columbia Public Defender's Office; and Inspector Edward Spurlock of the District of Columbia Police Department. Gentlemen, let's go to our first dramatized episode.
How you doing, sir?
Yeah, I'm all right. How you?
All right. How about turn your car off for a second while I talk to you?
Why? What's the matter?
You don't have any tags on your car, for one thing.
Who?
Turn the car off, sir. There you go. Why don't you step out of the car?
For what? What do I do?
Just step out of the car for a minute, sir.
All right. No problem.
Just stand right there for a second.
Well,
You
why
been
do I
drinking?
stand here?
You been drinking?
No, man.
Ho.
Just get a cigarette.
Don't do that.
Just get a smoke.
Don't do that.
I'm relaxed.
Come on around this
Come
way
on,
here.
car.
Come on out. Come on out.
What's all this about?
Come on over here.
What y'all messing
Put
with
your
me?
hands on the. Put your hands up there, sir.
Man, what are you
Put
messing
your hands
with
up there.
Man, y'all messing with me. Why don't you go lock up criminals instead of messing with me? Hard-working man.
Let's discuss this first dramatized episode. In one or two words, do you think the police acted properly in patting down or frisking this suspect? Mike Farrell.
No, but subject to a qualification.
Ed Spurlock.
Yes.
Jim McComas.
No.
You said no emphatically. What did the police do wrong?
In order to frisk or pat down a suspect, the police are required by Fourth Amendment law to have an articulable basis for thinking that the individual that they're so frisking is armed and dangerous or has a weapon readily accessible. There were no facts to support that. He wasn't being placed under arrest. It was just an investigatory search of the person's body, and it was improper.
Ed Spurlock, why do you think it was proper?
Well, the procedures, as the officer on the left side looked in the back seat, he motioned for his partner to go around. That's a signal that the man's dangerous. He saw something inside that car.
We'll see in a moment whether he saw anything. Does it make a difference that the person, when he got out of his car, reached for his jacket for a moment?
Well, the officer was right to stop him from reaching inside his jacket, but he would have had to have a reasonable fear for his safety to justify the frisk.
Do you think he was right to stop the man from reaching to his jacket the way he did when the man said he was going to
I don't think there was any problem with that.
The problem began when he put him over the hood of the car.
And put him over the hood and then felt down his body without, so far in the facts, anything to support a belief that there was a danger to the officer.
Mike Farrell, explain your answer.
Essentially, I have to agree with Jim, subject to this qualification. In many jurisdictions, police officers could arrest and not simply issue a citation, but could arrest this individual for driving without a license plate and indeed for driving while intoxicated. In that event, they would have had ample ground to conduct a full search of him and not simply a frisk. On the facts here, it does not appear that they intended to arrest him without some further indication that he was indeed drunk.
Well, let's see the next episode in this scenario to discover what happens next.
Damn, I'm no criminal.
What about these 2 shotgun shells here, sir?
What shells? I don't know nothing about them.
How
Y'all
about
put them
these?
there. They weren't in there. You put them there.
I put them here?
Yeah, you put them there.
Okay. Let's see what else that I'm going to put in here.
Why the hell y'all messing with me?
What kind of work you do, sir?
I do construction work.
Construction work.
Why?
Who you work for?
None of your damn business who I work for.
Okay, that's all right.
Work every day. Trying to make a living, y'all out here harassing me.
You drink every day too, don't you?
I don't drink.
You don't drink?
No, I don't drink.
What do you do with a gun?
What gun?
Gun that's in this briefcase.
I don't know anything about it.
You don't, huh?
Let's again get a one-word answer and start with you, Jim McComas. Was it proper for the police officer to look inside the briefcase where he found the gun?
I would say in this case it was all right.
Ed Spurlock.
Yes.
Mike Farrell.
Unquestionably, yes.
Mike Farrell, why was the answer unquestionably yes?
You have to proceed in 2 stages. The police certainly could look into the car from where they were standing outside. Indeed, that would not even be a search under the Fourth Amendment because anybody could see into the car from there. Once they saw the shotgun shells, they had unmistakable probable cause to arrest this individual, and any objective police officer probably would have arrested him.
Why is it a grounds for arrest if the person has shotgun shells in his car?
Because in most jurisdictions, the possession of unregistered ammunition is a crime, and when police see shotgun shells there, that gives them at least probable cause to believe that a crime has been committed.
Ed Spurlock, do you agree with that reasoning?
100%.
And Jim McComas?
I agree with the result, but not the reasoning, Jim.
All right, what's the reasoning difference?
The way I would analyze this is that the combination of the shotgun shells plus the suspect's denial that they were in the car created grounds for articulable suspicion that the person was armed and dangerous. If he'd said, yeah, those are my shotgun shells, I'm on my way hunting or something like that, it would be another thing. But instead he denied it, and the Supreme Court in Michigan v. Long has said that pursuant to a lawful stop where there's an articulable reason to think that there may be a weapon involved, officers can essentially frisk the passenger compartment to include containers of an automobile, and here they did it. So on that ground, I'd agree with the result that the others suggested as well.
All right. Let's now look at the final episode in this little scenario of a street stop.
My lawyer going to hear about this.
Good. You're going to need him.
Stand up, sir. Stand up.
Damn harassment, that's all it is. What you going in there for? What you looking in there for?
Stand right here, sir.
Man, you got no right in there.
Was the officer right to start this next step by looking inside the trunk? Ed Spurlock.
Yes.
He was. Mike Farrell.
Yes.
Jim McComas.
I'd say probably was.
Even though, in this case, he didn't find anything.
Whether something's found or not, of course, Jim, as the Supreme Court's long recognized, is not at all even relevant to a determination of whether Fourth Amendment rights have been violated. In that way, anytime something was found, there would be no Fourth Amendment violation, and if nothing was found, then it would be said there would. That is, the law applies equally to everyone. Here, I think had he found bullets in the back and the gun, he couldn't have gone in the trunk at that point.
Why not?
Because then he would have found the gun and the bullets that the gun went to, and there wouldn't have been a further reason to believe, since there was no report of crime, that there was other evidence in the trunk of the car. Since the man was now in custody and couldn't get into the trunk area, there wouldn't be a justification. But since he found shotgun shells and he found a weapon in the briefcase, the possibility that there was further evidence, perhaps a sawed-off shotgun or something like that, would have created, I think, probable cause for the search of the trunk, even though nothing ultimately was found.
Is that your reasoning, Ed Spurlock?
Exactly. I would agree that had those bullets that he saw from public space, from outside the car, been rounds that would fit that weapon, with no other circumstances, he would have been illegal to go in the trunk, as far as the search is concerned.
Why is it that once they found the handgun, and let's assume found ammunition that would fit into the handgun, they couldn't say, well, maybe he's got a sawed-off shotgun in the trunk, maybe he's got drugs, maybe he has other form of contraband. Why not continue the search then?
Well, it's not a reasonable conclusion. With no gun, no shotgun available but shotgun shells, it's reasonable to conclude that somewhere in that car there's a shotgun. Then the logical place to look, shotgun won't fit in the dash in most cars. It already looked under the driver's seat. The logical place to look, it would be in the trunk, and it would have been a reasonable search.
Let's turn to our next scenario. In our next scenario, the police have received word that suspicious persons are walking down an alley.
How y'all doing today? You gentlemen got any ID?
Nah, man, I don't have none. What's the problem?
Oh, we just want to know if you got any ID.
Nah, who, me? I left it at home.
You live around here?
Yeah, I live on Longfellow Street.
All right, in this case, all the officers knew was that there was a suspicious person otherwise undescribed in the neighborhood, and the officer stopped a person by putting a hand on his jacket. Was he right to do so? First, Mike Farrell.
No.
Ed Spurlock.
No.
Jim
Clearly
McComas.
illegal.
Clearly illegal. Why was it clearly illegal, Jim McComas?
The Supreme Court has taught in Brown v. Texas that it is okay to initiate contact with a citizen, but that if you're going to stop the individual, even momentarily, or even to request identification, if you're going to restrain their freedom of movement, then you have to have articulable suspicion. That's more than whim, more than hunch, and here there was no support for that.
Do you agree there was no support? They did have a report that there were suspicious persons indicated by a neighbor in the area.
Well, I agree that they were justified in approaching them and even asking for ID and attempting to engage them in conversation. But the citizen certainly had a right to refuse to present ID and had a right to refuse to talk and continue on his way. The officers could not have legally forced them to stay.
Mike Farrell, do you agree with this reasoning?
I agree with that. There's no question that they were free to approach and ask questions and solicit identification, but the law is that people in these circumstances must be free to refuse to answer those questions and go about their way.
You know, when we talk about these situations, I think it's important to realize also what's at work here, Jim, and that is it's the right of people in their neighborhood without any real articulable basis to be free to go about their business. This could have happened to anybody walking in their neighborhood. There could have been a confusion or something like that, and most people don't want to have whims or anonymous calls being a basis for their freedom of restraint in the absence of any other cause or articulable suspicion. And that's the value that's at stake here.
Ed Spurlock, doesn't it make that fact make it difficult for the police to do their work? These people could have been more than suspicious. They could have been casing the neighborhood. They could have been leaving the scene of a crime. Doesn't it make it awfully difficult to do police work if you can't simply stop persons and say, give us identification? Shouldn't that be within the rights of the police to ask that?
I don't believe so. In this situation, the facts were clear. They had nothing to go on other than they would simply want to talk to these two people, that maybe they were suspicious, maybe they were doing something. They were trying to find out what it was they were doing. Without additional information, they had a lot of restrictions on them. However, each thing that occurs from the approach would add to the officer's rights and give him probably, if you would advance that a little bit, if they started to run, that would add to their probable cause, to their reason to stop, and thus would justify possibly the use of force to even stop them.
Well, let's continue to advance the events and look at this. In this next version, the police have received a report of a burglary, as well as a brief description of the suspects. The description is of two black males, one tall wearing a green jacket, the other person smaller.
Hey, man, get your hands out your pockets. Get your hands out your pockets. You, right here on the car, on the car, on the car, on the car, on the car. You, the man, right here on the car, on the car. Hey, man, right here, on the car.
What's the problem, man?
Stretch out, stretch out.
Stand there, don't move.
Hey, man, easy, man. Man, you got me laying across this car. What is the problem?
Give me this hand, man.
Man, you gonna tell me what's going on? What am I under arrest for?
All right. The men were clearly placed under arrest. Were the police acting within their rights to arrest these two individuals? Ed Spurlock, you first.
No.
Mike Farrell.
Based upon the tip which the police had, I think probably not.
Jim McComas.
No, not at all.
Well, this, again, I think would puzzle many viewers. They had a description. The description fit them in. There was a report of the burglary in the neighborhood. What should they have done when they saw these men? Mike Farrell.
What they could have done, Jim, is to stop the men, to frisk them, perhaps to detain them there while the people whose home had been burglarized, had they had any contact with the intruders, were brought to the scene to make an identification. They could have probably done a records check over the police radio on these particular individuals to see whether there were any outstanding warrants or anything. But beyond that, there's not a great deal they could have done. They could not have arrested him, I think, based upon a tip which simply said that you had two black individuals, one taller than the other, one wearing a green jacket. A frisk was certainly permissible. A detention for further investigation of comparatively brief duration was permissible, but a full-fledged arrest was probably too much on the facts of this case.
Do you believe they were right to stop and detain and pat down the individuals?
The place where I'd part company with Mike on this one is the frisk. I think they plainly had Terry grounds, articulable suspicion to stop the individuals and to put questions to them, to continue their investigation and see whether or not these people were in fact connected to the crime that had been reported. I don't think that the reference, though, over the radio with no elaboration that a burglary had been committed without any indication that the people were armed or dangerous would have supported a frisking of them from the beginning. As Ed Spurlock pointed out, though, it might be in asking them questions that the police would get conflicting answers or other information that would escalate the justification for them to proceed to greater levels of intrusion.
They could have asked them for identification.
More than that, they could have stopped them and required them to stay at the scene for what the court in Terry v. Ohio refers to as a brief investigatory stop. Unlike the one we saw before, Jim, here, had one of them tried to leave, the police were within their rights to physically require them to stay on the scene, that is, to stop their movement.
Let's see what happens next in the final episode of this scenario.
All right. Oh, what we got here?
All right.
Got a piece.
Here, I'll close it up.
Raise up something, man.
Let's assume for the moment that the arrest had been valid. What we saw now was the search of the briefcase and the search of one of the individuals. Were these searches proper? Mike Farrell?
Yes.
Ed Spurlock?
Yes.
I'd have to disagree.
Why do you disagree?
I think once the suspects had been, as we're assuming now, validly arrested, and as we saw, handcuffed and up on the hood so that they were incapable of getting into the personal luggage, the briefcase, that under United States versus Chadwick, the police did not have authority to go ahead and open up that container without a warrant. Normally, the police can search incident to arrest the person and surrounding area of somebody that they arrest in order to protect themselves and to keep evidence from being destroyed. But I don't believe, since there was no report that the burglar was while armed, they had probable cause to go into the container, and even if they'd had probable cause, once the emergency of the suspects getting access to whatever might be in the briefcase went away because they were handcuffed, the police should have applied to a judge to make the decision about whether there was enough justification to go in that briefcase.
Ed Spurlock, why do you think they were right to look in the briefcase?
Well, I'm assuming that the arrest was lawful.
Yes.
The briefcase, under the current laws, and I think as close as a year ago, we were forbidden to do that. We now can't actually look in briefcases and things like that, incident to an arrest. The subsequent check for the narcotics and search of the body was incident to the arrest, so I see nothing wrong with what they did.
Do you disagree with the search of the body?
No, I agree with the drugs were lawfully seized incident to the arrest. Whether there was any reason to think there were drugs were there or not, that was fine. It was the opening of the briefcase.
Mike Farrell, you've heard two different versions of this. Ed Spurlock has said, well, the law has changed. How do you come down on the briefcase search?
To begin with, it's quite clear that the only issue here is the briefcase search. The recovery of the drugs presents no problem. Everyone agrees with that. Jim cited a case called United States versus Chadwick, suggesting that the police cannot search the briefcase under these circumstances. While we don't want to get into a lot of fancy case names here, there is other Supreme Court law, which I would argue, by analogy, says that when the police have lawfully arrested a person, they can search his surrounding area, his immediately surrounding area, for evidence or for a gun or weapon that might endanger the police safety. The cases which have demonstrated that have been particularly in the context of somebody being arrested in their car. That is, once they have arrested the driver of a car and gotten him out of the car and handcuffed him, they can nevertheless search the passenger compartment of the car and any container that's in there, like the briefcase in this case. I would argue that, by analogy to that, once the police have arrested a person on the street, not in a car, validly arrested him, they can search the immediate area surrounding him, and the law is not going to inquire as to the present ability of that defendant to reach into that suitcase and grab a gun. So the fact that he is handcuffed is irrelevant in my view. The Supreme Court has been intent on drawing a bright line for police, and the bright line is that when you have reduced a person to your control, pursuant to a valid arrest, you can search his immediately surrounding area and containers which he is carrying or which lie on the back seat of his car.
Let's now turn to our third dramatized scenario. This involves the police responding to a call at someone's apartment.
Yes, officers, come in. What's the problem? My boyfriend is in here. He's got a gun.
Get back over here. He's got a what? You got a gun?
He's got a gun.
I don't have no gun. This is my place, and I don't want you looking around in here. I want you gone. I didn't call you in here. This is my house, and I want you out of here.
All right. The police entered. The woman invited them in, but there seems to be a dispute between the man and the woman as to whose apartment it is. The man said it's his apartment and he wants the police out. Starting with Ed Spurlock, should the police have entered when they did?
Yes, they were invited in. It was obvious that there had been something going on, that the furniture was in disarray. And the minute that the male started toward the female, as if to do her bodily harm, they had to come in. Even if they were standing in the door, had not entered, they would have had to enter at that point anyway.
Mike Farrell, do you
I agree with that.
Jim McComas, do you agree?
I'd have to say no, I don't agree. And the reasons I don't agree is this. First of all, although it's still somewhat debatable, probably actual authority to consent is required. And there's no information here to lead us to believe that this woman had any relationship to the apartment to give her the actual ability to provide consent. Second, which Ed mentioned, the possibility that the police had to come in to stop what basically might be an assaultive encounter between the woman and the man. There is some case authority in the District of Columbia for that kind of an entry, but it must be limited only to the situation that gives rise to the entries.
Now, if the police believe that there is some disturbance going on here, possibly the likelihood of violence, how are they supposed to decide who owns the apartment?
What might happen in this case is that the police would enter in their order-maintaining function and prevent any further problem. It might later turn out, however, if the woman didn't have actual authority to consent, that it would be a bad search on Fourth Amendment grounds.
Ed, how would your officers handle this? How would they go about deciding who was right with respect to ownership of this apartment?
Well, they haven't gotten control of the situation yet in order to determine that, and that's an important point, but not now. They were called there. It's part of their mandate to respond to calls for police service. They came all the way into the apartment only to stop the male from getting to the female and doing bodily harm.
Let's find out now what happens next in the continuing story of the man and the woman in the apartment.
What's the problem?
He got a gun. He told me he's gonna kill me. He's got some dope. Get it out of here. I don't know where it is.
Ain't no gun in here.
It is.
Okay, Tom, you put some dope in this coat right here.
Check
I'm gonna check it out. All right, now, miss.
You stay right there, okay?
Stay right here now.
I don't know what
And
y'all
don't you
doing.
even think
I
about
didn't call
moving.
you. I'm not moving. It's not my coat.
It is too.
It's not.
It is.
Coat was there when I came in here.
Lies and garbage. It is your coat.
We're going to take it on her word that it's your coat.
And he was standing right there. I don't know what he did with it.
Ain't no gun in here.
Put that chair up.
I don't even know what she's talking about. That's not my coat even.
Okay, you see him with the gun. Where did you see him with the gun last?
Look back there. He probably hid it back there. I don't know where he
hid it.
Yeah. Look back there. It's probably where he hid it.
Okay, I got him.
It's your coat.
We've been having problems. I stayed out last night. She just mad. She called.
Was he right to go into that other room and look for that gun?
In order to provoke my colleagues to a contrary reaction, I'll say yes.
He was right. Ed Spurlock.
He was right, but with an explanation. He should have established her right to give consent to the search before he went in.
Jim McComas, was he right to go in the other room?
I would say no, because I don't believe there was that authority on her part to consent.
All right, Mike, you've provoked your colleagues. What is your explanation?
My explanation for saying they could go into an adjacent room, we have to assume when they went into the adjacent room and found the gun, for purposes of my position, that they found the gun in an open space, simply on the bed, on the floor. The reason is that when the police have a report that somebody has committed a crime, an assault here, he has threatened her with a gun, they have not found the gun in the immediately surrounding area, I think the police have to be permitted the latitude to make a quick search into adjacent rooms to see whether that gun is lying in an exposed place. It's almost, the rationale for that is not necessarily even a criminal investigative rationale. It may be akin to a kind of a community caretaking rationale, that the police have an interest in seeing that inherently dangerous weapons, such as a gun, are not left lying around so that other people can have access to them, even though they have arrested the particular person who
Well, let me ask
the
you this. Were they right to look in his jacket where they eventually found dope?
Unmistakably, yes, and I hope my colleagues won't disagree with me on that one. The reason being that they have had a report of a crime, namely she has told the police that he threatened her with a gun, that it is an assault, he was therefore subject to an arrest, and under a conventional search incident to that arrest, they were free to search his immediately surrounding area because he could reach into that area.
Ed, does the search of the jacket give you any trouble?
Yes, it does.
Why?
And again, for prosecutive purposes. The arrest took place, if I remember correctly, after they found the narcotics.
Yes.
The full custodial arrest did not take place until after the narcotics. Established that the jacket, they took her word, the jacket belonged to her. At that point in time, clearly I believe that it would have been a violation of the law.
Jim, how do you come on?
I'm in agreement with Ed on this one, and it points up an interesting point. Theoretically, Mike is right. The police might have been able to arrest for the assault and then search the surrounding area incident to that, but it's plain from the facts that isn't what they did. And the problem here was that if we went as far as Mike and Ed suggested by letting the officers come in a peacekeeping status just to prevent more fighting, that then her saying, oh, by the way, he has drugs in his jacket, turns the peacekeeping function into an investigatory, warrantless search of a home, and that would be improper.
Let me see if I can try to summarize for us. The Constitution prohibits unreasonable searches, but it does not tell us what is unreasonable. In general, police can stop a person when they have a reasonable belief that criminal activity may be afoot. He can be frisked when the officer has reasonable belief that that person may be armed and dangerous. He can be searched if he has been lawfully arrested, either on a warrant or if the officer has probable cause to believe the suspect has committed a felony. That search can extend to the person and place and things under that person's immediate control. A more extensive search, for example, of rooms in the house beyond which the room in which he was arrested usually requires a search warrant. In applying these rules, the courts try to balance the need of public safety and individual rights. For Crime File, I'm James Wilson.
Funding for this program was provided by the National Institute of Justice. This program was produced by the Police Foundation, which is solely responsible for its content.